There's a new decision out of the North Carolina Court of Appeals that has created an absolute procedural nightmare for the plaintiff, and it's got some good lessons in terms of what to avoid. This is the continuation of a series I'm doing where I'm walking through recent Court of Appeals decisions and Supreme Court decisions. I've been going through the factual background of these decisions and then explaining the court's reasoning and the holdings. My goal with these videos is that they'll be helpful to other lawyers like me who are trying to keep up with the new developments coming out of our appellate courts. And I also know that a lot of people find this stuff interesting, and so I'm hoping that those who are interested in this type of topics will find it informative and edifying. This is a decision that came out on April 16th, 2024. The case is titled TH, that's the plaintiff, the plaintiff's initials is TH, versus SHL Health Two Incorporated, doing business as Massage Envy Arboretum, and then there's two individual defendants that are named. Now I should say that I don't have a lot of information about this case other than what's contained in the appellate opinion. I went to try to go look for the appellate documents, looking at like the record on appeal, to get a little bit more background on the decision, and all that stuff's restricted. So based upon that and the fact that we're getting a plaintiff's initials and who the defendants are, my suspicion, and I don't know this, but my suspicion is that the underlying case involves some sort of abuse with a massage facility. So basically, all the way back in October of 2020, this law firm filed a lawsuit against all these defendants on behalf of multiple different plaintiffs. The trial court decided that it wanted to sever all of those separate plaintiffs into their own distinct lawsuits. I don't know why that was done. Oftentimes when you have cases that are all arising from the same sort of set of facts, it's more efficient to treat them all as one case. Because if you start separating them out, then you end up where you're maybe taking multiple depositions for the same issues, you're doing multiple sets of discovery, multiple motions, you do a motion and a brief in every single case. And if the cases all deal with the same issues, that can be really inefficient. But for whatever reason, the trial court in this matter decided that that was the best way to do this. What the court ordered was that the plaintiff file an amended complaint in that action with all the other plaintiffs. And what the judge said was that the clerk of court would then separate out each individual plaintiff into their own lawsuits with their own distinct case numbers, I'm guessing based upon that said amended complaint. So the plaintiff's lawyer puts together this complaint, and instead of filing as an amended complaint in the already existing case, he files it as a new matter. Then the plaintiff's lawyer discovers, I don't know if someone told him or he realized it, that that was a mistake, that wasn't what the court wanted. And so he talked to the defense lawyer and asked the defense lawyer if he would consent to a voluntary dismissal. So he gets the consent from defense counsel to do the voluntary dismissal, but he doesn't do it right away. First, in September, he does what the court wanted, which is he files that amended complaint in the original action so that it can be dispersed into all these separate cases. Then, here's where maybe the mistake happens. What this really comes down to is the difference between filing a dismissal with prejudice versus without prejudice. If you file a dismissal without prejudice, that means you're doing it while preserving any right you may have to file that case again in the future. On the other hand, if you file something with prejudice, you are foreclosing your ability to bring that case up again in the future. And that's what the plaintiff's lawyer did in this case. They filed a voluntary dismissal with prejudice in the second case. Well, the defense counsel then turned around the next month and filed a motion to dismiss the first case, the amended case, based upon the fact that this same plaintiff had now filed a voluntary dismissal with prejudice in the other case. And the plaintiff's lawyer goes, whoa, that is not what I was intending to do here. I did not want to bar this case. I was just trying to basically accomplish an administrative task to get this case off the books. I didn't intend for this to be a dismissal that was going to bar my client's claims. And that's what the dispute becomes about. So he files a motion under Rule 60 seeking relief from that voluntary dismissal with prejudice. Under Rule 60b1, a trial court may relieve a party or his legal representative from a final judgment if the judgment stems from mistake, inadvertence, surprise, or excusable neglect. So if any of those things are true, a trial court is allowed to step in and grant relief to correct the error. And the court gives an example of where this has happened in the past. The example is a case called Carter v. Clowers. Basically, there were two defendants, and the plaintiff intended to dismiss one of the defendants from the case, but instead dismissed both of the defendants. And the lawyers had talked about how they were going to dismiss just one of the defendants. And the Court of Appeals said, yeah, we're going to let you fix that problem because procedural actions that prevent litigants from having the opportunity to dispose of their case on the merits are not favored. We want people to reach conclusions in their cases based upon the merits of those cases, not based upon a procedural misstep by the lawyer. The Court of Appeals in this case compares Carter with another case called Couch. And in that case, in the Couch decision, they wouldn't let the plaintiff's lawyer fix the error because they concluded that the voluntary dismissal with prejudice was a carefully considered decision, a trial strategy, and thus constituted a deliberate, willful act precluding relief under Rule 60b-1. And here's what's important. They go on to say that a misunderstanding of legal consequences is immaterial. The plaintiff says this was a mistake. I didn't intend to do this. And the court says, well, hold on. Was this a mistake in the action that you took? Meaning you did one thing when you meant to do the other? Or was this a mistake in outcome? That you thought you were going to get us one goal, but you really got the other? Because if it's a mistake in action, if you intended to take one action, but instead you did the other, then you can get relief from that. But if it's simply that you intended to achieve an outcome and you accidentally achieved a different outcome, then there's no relief for that. Now, there's one other twist to this. The plaintiff's lawyer filed an affidavit in which he said, "At no time did I express any opinion or legal reasoning that these incorrectly filed matters must have been dismissed with prejudice." So he's basically saying, at no point was it my belief that these things needed to be dismissed with prejudice, and that I was doing that on purpose, that I intended for them to be dismissed with prejudice. And I think that was in response to an affidavit filed by the defense lawyer. And the defense lawyer said that the plaintiff's lawyer told him that the plaintiff's lawyer believed he had no choice but to dismiss with prejudice. And that the plaintiff's lawyer explained his legal reasoning for filing dismissal with prejudice as opposed to filing without prejudice. And the defense lawyer's point by saying that is to say that the plaintiff's lawyer didn't make a mistake. It wasn't like he didn't realize that he was filing it with prejudice and he meant to file it without prejudice. The defense lawyer is saying, "Judge, he told me that he was going to file it with prejudice and explained to me why he was going to file it with prejudice." And the plaintiff's lawyer says, "That's not true." And the judge says, "You know what? I believe the defense lawyer. And because I believe the defense lawyer, I am therefore concluding that you, the plaintiff's lawyer, intended to file this thing with prejudice. And that more likely than not, you just didn't know the consequences of that decision." That's a nightmare for a plaintiff's lawyer. Well, the court doesn't end there. The plaintiff had also sought relief under Rule 60b-6. And some people would call that a catch-all provision. The court explicitly says, do not call it a catch-all provision. That's not what it is. 60b-6 allows a trial court to grant relief to a party or his legal representative from a final judgment if there is any other reason justifying relief from the operation of the judgment. The key word there is other reason. If any of the earlier reasons in the rule just don't apply, then you can go to 60b-6. But if one of them applies, you have to do the analysis under that rule and under that rule only. And in this case, mistake is 60b-1. So it does apply. And so your chance for relief is limited to 60b-1. And so if you can't get it under 60b-1, you can't then turn around and seek the same relief under 60b-6. And then finally, as if that's not enough, the court goes on to say that even if the trial court was allowed to grant relief under 60b-6, its refusal to do so was not what's called an abuse of discretion, which means it's going to give a lot of deference to the trial court. And it's only going to overturn the trial court's decision where the court's ruling is manifestly unsupported by reason or so arbitrary that it could not have been the result of a reasoned decision. And so the court says even if the trial court was able to grant relief under 60b-6, its decision not to was not an abuse of discretion. Why? Well, because the trial court found that the plaintiff's lawyer made materially untruthful statements to the court. And then on appeal, according to the Court of Appeals, the plaintiff didn't challenge that finding of fact. And if you don't challenge a finding of fact on appeal, the Court of Appeals is going to consider it as true. And so as far as the Court of Appeals is concerned, the plaintiff's lawyer did make untruthful statements. And if the plaintiff's lawyer made untruthful statements, then it was a completely reasonable decision for the trial court to say, I'm not going to grant you this extraordinary relief. So that's this opinion. Unless there's a further appeal, the case is dismissed and the plaintiff is without relief. It's a unanimous opinion, and I think it is a warning to plaintiffs' lawyers to be incredibly careful when filing a voluntary dismissal with prejudice, that you need to be absolutely sure that you understand all the implications of that decision before you file it. That's certainly the takeaway that I'm taking from it. I hope that this video has been helpful in explaining this decision. This video is a continuation of a trial run that I'm doing where I'm breaking down recent legal decisions. If you found this video helpful or interesting, be sure to leave me a comment to sort of encourage me to keep making them. And in the meantime, if there's anything else I can do for you, don't hesitate to reach out.